The other big story, after the Lok Sabha, now the Rajya Sabha also passed the 3 criminal bills that replace the IPC, the CRPC and the Evidence Act. The legislations were meant to overhaul the criminal justice system but have sparked a furious debate. Is it a landmark reform or an attack on civil liberties of citizens? While backing the change and bringing in the Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita and the Bharatiya Sakshya Sanhita, Home Minister Amit Shah called them the need of the hour. He said that they are intended to prioritize the people of India and to leave colonial vestiges behind.
कई सालों से आईपीसी 163 साल से, सीआरपीसी 125 साल से और एविडेंस एक्ट 150 साल से जो ब्रिटिश पार्लियामेंट ने बनाए थे वही एक्ट को आज हम उसी एक्ट से आज हम गवर्न हो रहे थे। नरेंद्र मोदी जी ने आजादी के 75 साल बाद इस देश में सारे कॉलोनियल कानूनों के अंदर उसको बदलाव कर कर समाप्त कर कर भारत की आत्मा को प्रस्तावित करने की शुरुआत। पहले ट्रेजरी के खजाने को लूटने का गुना, रेल की पटरियों को तोड़ने का गुना, अंग्रेज शासन के खिलाफ षड्यंत्र करने का गुना, इसकी प्रायोरिटी ऊपर थी। मानव हत्या की प्रायोरिटी और बहन बेटी के साथ अत्याचार की प्रायोरिटी बहुत नीचे थी, क्योंकि अंग्रेज शासन का ये उद्देश्य ही नहीं था। उसका उद्देश्य दंड देने का था। जो शासन के खिलाफ काम करते थे उसका उद्देश्य जिनके साथ अन्याय होता है, जिन पर अत्याचार होता है, उसको न्याय देने का नहीं था।
Okay, so let's take this question straight across to senior lawyer on the Supreme Court, Mr. Colin Gonsalves, and former ASG, Ms. Pinky Anand. Mr. Gonsalves, why are there apprehensions about these 3 laws? Right now, the Home Minister, when he was speaking, he said this is essentially an overhauling of ancient laws.
Well, let's take a close look at the laws. And I heard the minister say this is British Zamana. Those are the kind of laws that we are now modernizing and humanizing. Let's look. Let's take a cursory look at what laws he's actually made, apart from the talk and the words used. First of all, police custody under British period, police custody under Indian law, right up to today, is a maximum of 15 days in police custody. Why? Because even our colonial masters realized, even the British realized, and Indian Parliament realized, torture takes place in police custody, not in judicial custody, not in the jails, but in police. Under the new laws, you can keep a person in police custody up to 90 days. Unheard of. Unheard of anywhere in the world, unheard of in India. Second point. Let's go now to the terrorism provisions. And we heard the minister say that now we'll do something on terrorism. Already you have an act. It's called the UAPA, Unlawful Activities Prevention Act. It deals with terrorism. Now the terrorism provisions are brought into this law. So far, so good. Same provisions brought here virtually. But the important thing which the minister is not telling you is that 2 of the safety provisions in the terrorism law, which Chidambaram introduced in Parliament when there was a hue and cry that you are bringing a draconian law, hue and cry, 2 of the safety provisions that he introduced have been removed. What are these? First, sanction. Sanction means the police officer, when he finishes his investigation, can't straight away go and file a case on terrorism. Can't. Because police officers can be influenced by A, B, C. So Chidambaram introduced a provision called sanction, which is there in other laws as well. Sanction has to be granted by the government. Government has to, independent of the police, apply their mind and say, you can proceed, you cannot proceed. This important safeguard deleted. Second is the authority.
Okay.
Second provision. The authority is a senior expert who will look at all the evidence that the IO has gathered and then analyze that evidence and say, is this case worthy of going forward? that second safeguard deleted. Therefore, what do we have? If UAPA was called draconian and the Congress linked it was UAPA, this is a triple E draconian act. UAPA, without sanction, without authority, without safeguard.
Okay, Mr. Gonsalves, I'd like to put you on hold for just a second over here. Ms. Pinky Anand, respond to these two main objections. One, why this unprecedented 90 days? Two, why this UAPA Part 2 when you already have an anti-terror law?
See, I don't know where this really conversation is going. To the extent that when you're dealing with terrorism, if you have effective laws put into place which deal with terrorism, why should there be this concept of even opposing it for one? Second, what basically terrorism includes as defined under the IPC at present is something which threatens the unity, integrity, security or economic security of the country or strikes terror at the people. So if you have a provision, frankly, I don't think terrorism is a ground to start a discussion by any group. It is something which threatens the nation.
Ma'am, because the concern is about misuse of these laws to brand people terrorists, and two, when you already have a law, why have another one?
The point is that both IPC and the other laws have been meant to deal with each other. If you define the provision of terrorism, which it has been defined in the current laws, the idea is to make it part and parcel of the entire criminal justice system. I don't think there is any question of what is to prevail. You are ultimately dealing with an offense. How does it matter and why is there this apprehension, so to say? This apprehension has been there forever. Somebody will be branded as a terrorist and some further eventualities will come. The systems have everything put into place. It is not anybody who can be defined. It is defined.
Okay, Mr. Gonsalves, apprehension of misuse cannot be reason to not have a law. That's the argument.
See, if you make a draconian law, you tell the public you're making a draconian law. Don't say, okay, British law. And most important, who is this sanctioning authority? Who is this authority? It's the central government itself. Experts from the central government will decide on sanction and decide on authority. And you don't even trust them for that. You just want the police to do the bidding of a local politician and so on, and catch people who are speaking out against government and put them in jail for terrorism. Even your own government sanction you don't want. Even your own government authority you don't want. You want draconian, unbridled power. So say so. Don't talk about colonial law. You want draconian law?
And it is not a question of government, so I don't know why we are talking about this. Your whole premise is misconceived. It is not against the government, it is against the nation. There's a lot of difference between the nation and the government. And this doesn't make it a lighter subject. And you cannot tell me that nation is equivalent to government. If you like, that's your statement.
Okay, shall I go to the next point? Why I think it's draconian.
Yes, go on.
Now the sedition law. We were told, and you know, Supreme Court has stayed sedition. No more sedition prosecution. Why? What is so offensive about sedition? Mere words constitute the crime. Strong words against the government, attacks on the government, strong criticism of government, all attack sedition. Under Indian law, we disagreed with the British law. And we said mere words can never be a crime. Mere words, no crime. But words coupled with insurrectionary action constitute sedition. Perfectly okay, we agree with that. Now you look at this. You look at the section as drafted. Whosoever by words. And then comes everything, which means those three words, whosoever by words. Those three words are lethal, which means, okay, violent acts and so on, we know, you take them in sedition, whatever you want to do. But words constitute a crime once again, after it's stayed by the Supreme Court once again. So remember Rangarajan's case of the Supreme Court on freedom of speech. Freedom of speech, even if it is hateful of government, mere speech, but no violence, is never a crime. Now let me go to the next point, FIR.
Let Ms. Anand respond to this. Mere words are a crime now, and they're sedition.
Ultimately, today, the Supreme Court has put the offense of sedition on hold. That is the position until the Constitution bench examines it. Now, BNS too has removed this offence. The first point that the Act has done is to remove this offence because of all these issues that have arisen. The question of having, again, actions that penalize exciting or attempt to excite secession, armed rebellion, look at the context. Let's not just talk about what it is. Words in a different context is different. This is in the context of exciting or attempt to excite secession, armed rebellion, subversive activities, separatist activities, endangering sovereignty or unity of India. So, Mr. Gonsalves, I'll leave it at that. Sedition of words where there is provocation or action is one part of it. But when you're dealing with the sovereignty and integrity of the nation, I think we do have a different criteria.
Mr. Gonsalves.
Very simple. Words, you have about 200 plus people, including journalists and students, put in jail. For what? They were not inciting rebellion. They were simply criticizing the government mercilessly. And this government doesn't like criticism. These ministers don't like criticism. They went to jail, not because they were, throwing bombs or doing this or doing that. They went to jail because they were merciless in their criticism of the government. And now this law, you say we've removed it. You removed the word. The sedition heading has gone. But it has come back in a different form. Same language. Whosoever by words
Exciting
the government,
or attempting to excite. Mr. Gonsalves, let's go to the other part of the words also.
That is the next thing. Okay, I'm saying just this is by itself a crime. It is mixed with violence, this, but it's not. It's not as if they are all connected. So whosoever by
Mr.
words.
Gonsalves, words which are attempting to excite or excite. You can't
delete it, no problem.
Isolation.
Pinky, no problem. You delete words. It'll be a perfectly rational section. Delete that. But you want it because you don't want anyone to have the audacity to criticize your ministers and particularly your top people. You don't want. You want to put them in jail immediately. How many have come out? The Pinjara Code people came out. The judge said, I can't find any crime.
Okay.
These young girls, 17, 18 years old, spend 1 year in jail. I don't find any crime. Pinjara Code. And that is like that. There are 100 cases. Kishore Chandra, the journalist in Manipur, used a bad word for a minister. Can you imagine he used a bad word? Is it not a nice thing to do? Yes, it's not a nice thing. Does it offend? Yes, it offends. But is it sedition? Tell a minister, you're something.
Okay.
He spent a year in jail, Kishore Chandra, your colleague, the journalist from Manipur.
Okay. This is an ongoing debate. I unfortunately have run out of time today, but the import of these bills, I think, will have to be debated at length about these laws. There are criticisms, there are concerns about what this will do to civil liberties. Is this genuine criticism? Are they very genuine concerns right now? And what does this do to the rights of the people of India? For the time being, though, thank you very much, Mr. Gonsalves and Ms. Pinky Anand, for joining us with your wisdom.